Hello, you're welcome to our channel. I am Mwesi Nyin. We are still on our agency series, and today we are looking at the relationship of principal and agents to third parties. And we'll be focusing on the issues that could ensue in such relationship and the possible solutions that the law has put in place for them to get one redress for the other. In every relationship the world over, offenses normally occur, and that's why it's popularly said, ubi jus, ibi remedium, meaning that where there is a wrong, there must be a remedy. So in the relationship of agents and their principals vis-a-vis a third party too, there could be breaches, and when there are breaches, one party or the other will have to take responsibility for such a breach by way of remedying the entire situation. So sometimes it happens that contracts entered into by agents on behalf of their principal are broken or breached. It therefore becomes necessary to determine who can sue or be sued in such cases. In this regard, the law determines when an agent is personally liable to a third party in a contract entered into on behalf of his principal, or where it is the principal that is liable to such a third party on the contract created by the agent on his behalf. The liability of either the agent or the principal to a third party is dependent on whether the principal is a disclosed principal or an undisclosed principal or a partially or partly disclosed principal. So, and each of these has its legal consequences. An agency is said to be fully disclosed if, as at the time of making the contract, the agent makes known to the third party the existence of a principal. And by making known to the third party the existence of a principal, he also fully discloses to the third party the principal's name as well as the principal's particulars. I've been in a situation where I needed to get a space, an accommodation actually, and on meeting these agents that get to people's houses, at a point in the transaction, the agent just said, okay, let me take you to the landlord. And that's how we entered into a vehicle and went straight to the landlord's house. When this type of thing happens, the landlord, who is the principal, is a fully disclosed principal. In the event of an issue coming out of that contract, the principal will be liable because it's a fully disclosed principal. But sometimes a principal is not fully disclosed. The principal is only partly disclosed. A principal is partly disclosed where the agent makes known the existence of a principal but does not give particulars of that principal. So that third party knows that, oh, this person is acting on behalf of someone, but does not know that someone that the agent is acting on behalf of. And in such circumstances too, it comes with its legal consequences. The principal in this situation is called a partially disclosed principal, to which event both the principal and the agent are liable to a third party in relation to a breach in that contract. The agent will also be liable for the reason that the third party relied on his reputation, integrity, and credit, since he did not know the identity of the principal. The principal will be said to be undisclosed, where the agent does not disclose his existence, does not disclose his name, nor discloses the existence of that principal altogether. Under this circumstance, he will be called an undisclosed principal. And in this circumstance, the agent who made the contract in his own name and without disclosing the existence of the principal is personally liable for contracts entered into with the third party, even though he is in fact merely acted as the principal's agent. And you see the authority on this in the case of First Bank of Nigeria PLC versus Excel Plastic Industries Limited, authorities supplied. We go to torts and crimes committed by an agent. When an agent in acting on behalf of the principal commits a tort or commits a crime, who will be liable in such a circumstance? Will it be the agent or will it be the principal? A principal is liable for the civil wrongs that are committed against third parties by his agent who is acting for him within the scope of the agent's actual or apparent authority. An agent is also liable for the tort committed by the principal where the agent has A. attained the age of criminal responsibility, and 2. perpetrated the act or omission constituting the particular crime. And that act or omission constituting a particular crime is known in law as the Actus Reus. And you will see this on the authority of Container International Limited versus Churchgate Nigeria Limited, authority supplied. So both the agent and the principal are jointly and severally liable for trespass committed on behalf of the principal. You see the authority given as Dunu Merchants Limited versus Obanye. You see the citation supplied. Now, regarding the personal responsibility of a principal, he is not personally responsible for the crimes committed by his agent in the course of his employment. He is generally not personally responsible for a crime committed by his agent because that's the general rule, but there are circumstances in which the principal will be liable or jointly liable with the agent in terms of a crime that is committed in the course of the agency relationship. And the reason why the position of the law is on the matter of crime is because crime is a special aspect of the law. The seriousness that is attached to crime is to the fact that every citizen is supposed to be responsible enough to know not to perform a crime. So when an agent in the course of his employment descends to the extent of committing a crime to favor his principal, he is also criminally liable as the person who committed that crime in person. The principal will, however, be responsible and liable if he participated in perpetrating the particular offense in issue or he ratifies it after having knowledge of it that it was so committed, and he also goes ahead to benefit from the profit that emerged from such a crime. He will also be liable. He will be held to have satisfied the position if he was found to have abated, to have aided, to have authorized, to have connived, to have instructed, to have counseled, to have procured, or personally taken part in the commission or omission which constitutes such a crime. And you see this on the authority of APC versus PDP, authority is supplied. We also see it on the authority of Oyegun versus Igbinedion, authority also supplied. The court held that an elected candidate could not have his election nullified on the ground of corrupt practices or any irregularity committed in the process of an election unless it could be proved that that candidate expressly authorized that irregularity. We also see similar cases such as ACB Limited versus Agbanyi, and also Coca versus Wycliffe. You see the authority supply. We now move on to vicarious responsibility of a principal. At common law, the general rule is that the principal is not ordinarily vicariously responsible for a crime committed by his agent in the course of his employment. In Tesco Supermarket Limited versus Nastra, the authority supplied, the general principle was stated by Lord Diplock as follows: save in cases of strict liability, where a criminal statute exceptionally makes the doing of an act a crime irrespective of the state of mind in which it is done, criminal law regards a person as responsible for his own crime only. It does not recognize the liability of a principal for a criminal act of his agent because his agent's state of mind, per se, is not a maxim of criminal law. So the above dictum raised the issue of when a statute should be considered as having created a strict liability offense. The general test applied in determining this is whether the duty or offense created is or has been rendered absolute thereby. If it has or is, the principal is responsible just as the agent, whether he has expressly delegated his duty under the statute to his agent or not, and regardless of any intent, knowledge, or mens rea. In addition to strict liability offenses, a principal may be vicariously liable at common law in case of libel or in the case of public nuisance. So, for general vicarious liability of the principal, see the authority of SGBN Limited versus Eleganza Industries Limited. You see the authorities as supplied. Thank you very much for this session. We hope you enjoyed it as we enjoyed bringing it to you. We have one more class in this series and we'll be done with the law of agency. Thank you so much. Till next time, I am Mwisi Nyim. Thank you.